The plea bargain agreement punishment is to be assessed at a cap of 5 years. This is to run concurrent with 2025 CR 0000071, 2025 CR 0000092. Those cause numbers, have you been sentenced on those, or those motions to revoke?
They're all new cases that got indicted. He doesn't have any pending motions to revoke.
Okay, pause here. That "I love you, bro" voicemail sounds sentimental, right? But in the context of a police report tied to an assault case, it instantly flips. Is it remorse, manipulation, or just timing gone horribly wrong? Stay with me, this gets deeper.
It's just there was a plea as to some and then summary TIC to resolve. Renee Munoz on behalf of Mr. Xavier Chamberlain.
And are you Mr. Chamberlain?
Yes, Your Honor.
Counsel, have you received all discovery in each of these cause numbers, and did you review it with your client?
Yes, that's to both questions, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number.
So, let's decode this. Assault of a family or household member with a prior conviction, we're talking third-degree felony territory. In Texas, that's up to 10 years in prison and a $10,000 fine. Not your run-of-the-mill misdemeanor. The fact that he entered a plea no contest, that means he's not admitting guilt, but he's not fighting it either. It's a legal move like folding in poker when you know your hand's bad.
Charged with assault family household member with a previous conviction. All of those are third-degree felonies with a range of punishment anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow the plea. If for any reason the court does not follow the plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
In each case, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right jury.
We're respectfully requesting PSI, Judge, and also if it could be made a part of the PSI, a TAP and mental health evaluation, as my client has some issues that I think PSI would be helpful for the court in this instance, at least have some background regarding that.
Here's the legal gold. The judge is crystal clear. If she doesn't like the plea deal, she can toss it. And guess what? That happens more often than you'd think. It's a warning wrapped in courtroom courtesy. Don't count on mercy if I see red flags. And spoiler alert, she will see red flags.
All right, then we'll schedule for a PSI TAP evaluation and MIC evaluation. What date, please? All right, July 15th.
End of flashback.
All right, have both parties had a chance to review the PSI report?
Yes, Your Honor.
Any objections?
No objection by the defense.
Well, I'm silent, but I'd just like to leave it.
All right, do you have any witnesses?
No, Your Honor, I believe procedural background justification as to what we believe is an appropriate course of action that we would ask the court to follow.
Just one second. State, any witnesses?
None from the state.
All right, then you may proceed.
Thank you, Your Honor. In reference to Mr. Chamberlain, I have been on his case ever since he got picked up on these offenses in October. I've met with him routinely, and this is an individual that I believe is grappling with drug addiction and does not have an innate sense of criminality, Your Honor. Ever since he's been in pending custody in the Bexar County Jail, he has done family violence individual counseling. I have those forms here, if I may show the court.
Any objection?
None from the state.
And so he has been working on those things. He has been learning about boundaries and effective ways to deal with stressors in his life as well, to not take him out in a violent way, Judge. There's some cases pending here, but if the court does take note, one of the offenses, there was no bodily injuries observed by law enforcement, and the other one, there was a small, slight little scratch. In dealing with the case and talking about the evidence and our avenues for taking this in front of the court in terms of sentencing, we did talk about certain inconsistencies within some of the reports, but that was more so before he accepted the plea. So he does accept responsibility here.
The defense is painting a portrait here. Chamberlain isn't a career criminal. He's a man drowning in addiction. Domestic violence classes, boundaries, emotional triggers, They're building a mitigation narrative. This isn't a monster, this is a man with trauma. But will it be enough to shift the judge?
Knows that he messed up. He knows that this was a toxic relationship with an ex that he shouldn't have been continuing, but he was in the midst of drug addiction. As noted in the PSI, he was under the influence of drugs at the time of these offenses, Judge. Also in the PSI, he has never had residential treatments. He has had outpatient treatment before, but because we believe that his needs are severe in terms of his daily methamphetamine usage before he got picked up, we feel like inpatient treatment would be more so suitable for him to get a grasp on his issues that he's dealing with. We're looking, Your Honor, in terms of his whole life and his future down the road. And in terms of serving the community and also helping Mr. Chamberlain work towards bettering himself, we feel that inpatient treatment would be more conducive in that we're able to address the root cause of this and hopefully put a stop to this from ever occurring again.
Okay.
If Mr. Chamberlain is institutionalized or incarcerated without the proper form of treatment, we feel that we may just be repeating this pattern of events that has been going on. Mr. Chamberlain has been to prison before, Your Honor, but this was about 20 years ago. When he was younger, did not get the appropriate treatment. He was essentially sent to TDC, released out, and had been battling homelessness as well as drug abuse. For these reasons, Your Honor, we're requesting a period of deferred adjudication as long as the court sees fit with inpatient treatments. And I did speak about if the court did approve inpatient treatment, what that would be looking like in terms of transfer to a facility and then having to be compliant with the terms of community supervision thereafter. Before Mr. Chamberlain was picked up on this offense, he did start school at St. Philip's College. He was about 1 month into that program until he got picked up on this offense and did not have the opportunity to bond out. But he had been working towards his HVAC certification, where he wanted to work in that capacity in terms of a career for himself, Judge. So in looking at his criminal history, he does have minor things such as theft, drug possession, a burglary.
Nice!
These are all things that I think were tied with drug addiction, drug usage. So we're asking that the court take a look to see if he's eligible to address the root cause of that addiction to stop this cycle of institutionalization.
All right, is there anything you wish to say, sir?
Yes, ma'am.
Do you want to raise your right hand for me, please?
Yes, Your
Do
Honor.
you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Xavier Chamberlain.
All right, you may proceed. What would you like to say?
Your Honor, I take full accountability for my actions and I'm very remorseful. But at the same time, I know that I learned a lot from this experience. I'm not the same person I was a year ago. And I just want to move forward in my life and just be a better person for my family,
You sit on a throne of lies.
for members of my community, and just get past this and just move forward. I'm so to be making mistakes and
But the question is, these are not mistakes, these are choices. Why do you keep making the same choices?
That line right there, these aren't mistakes. These are choices. The judge cuts right through the emotional fog like a scalpel. This is where courtroom reality hits prior convictions, a protective order violation, and repeated offenses. Judges don't just look at words. They weigh patterns.
Because you have previous convictions for assaultive behavior. That's why this is assault with a second conviction. So why do you keep making these same decisions? And then we have the violation of protective order. So there's a protective order in place. And when people violate protective orders, those are court orders. So that tells the court, if you're violating that, then you won't follow my orders because you're already violating a court's order.
I was under the influence of drugs, and
Sorry, what?
I was under the influence of narcotics, Your Honor, and I'm just trying to seek opportunity for treatment.
But you're under the influence of narcotics, but it didn't stop you from going to the location of the complainant in striking the
But
complainant.
what I'm
I was living there, Your Honor.
But wasn't there a protective order for you not to be at that location?
Not to my knowledge, and not until I was arrested was I informed of the protective order. My ex never told me about it.
Okay. All right, is there anything else? And on this case, what I can tell you, I don't have the trial court certification of defendant's rights to appeal. I know you probably filed it, but it's lost somewhere. So if you could do another one for me, please?
Yes, Judge, would that be one I have to get from them, or do they have them on?
Oh, they should have them on the wall now.
Yes. Four.
He took the last one.
Oh.
The clerks may have some more. All right, the cause number is 2025 CR 0000069.
These things go like hotcakes, Your Honor, these nights.
Oh, yeah.
They're custody. Your Honor, can I tender it?
Yes, thank you. All right, any further witnesses?
None from the state. None from the defense, Your Honor.
All right, so Mr. Chamberlain, I want you to know your attorney did a very good job for you because you have numerous cases that are open and pending, right?
That's right.
I just don't think that you're a good candidate for probation. So I'm going to find you guilty. There's an affirmative finding of family violence. There's to be no contact with the complainant. A $1,500 fine, time and money to run concurrently. This will run concurrent with 2025 CR 000071, 2025 CR 0000.
Boom. The gavel drops. Guilty. 5 years. Therapeutic community requested but not guaranteed. This sentence walks the line between punishment and treatment, but it's still prison. And remember, an affirmative finding of family violence means he's barred from owning any firearms for life. That's a serious label with lifelong consequences.
092, taking consideration 2025 CR 000070, 2025 AL 002118. Court will give you credit for any time served, the therapeutic community, and 5 years in the prison. With the therapeutic community, I have no jurisdiction to mandate that you be in the program, but they'll know in the judgment that I'm requesting the therapeutic community for you, so there may be either mental health issues or drug issues. You're still going to have to request the program, you understand? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
That's right.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney, okay?
That's right.
All right, we can go off the record. So here's the thing. When you are released from the prison, if you can't find a place that can help you with your addictions, you can always come back to here. If I'm here, then